In continuing our discussion on the subject of contractual terms, what we're going to do in this lesson is talk a little bit about the 2015 Consumer Rights Act. Now, this is going to essentially involve us reading quite a few provisions from the Consumer Rights Act. And this is obviously partially because the Consumer Rights Act is relatively well made and well written, such that it requires us to basically just be able to list off the provisions, and this gives us an indication of how contract terms may be implied into a particular contract on the basis of the fact that it is protecting the rights of a consumer. This is one of the most important ways in which terms of a contract or terms to a contract can be implied into an agreement that is under the auspices of the Consumer Rights Act itself. Of course, we're not going to spend huge amounts of time in this series of lessons on the law of contracts talking about the Consumer Rights Act in a great amount of detail. Theoretically, we could do. However, it is more important, at least in my opinion, to be moving on and talking about the elements of contract law that concern itself specifically with contracts, not necessarily with consumer rights and marketing law or commercial law, all of which are going to be subjects that I'm sure we will get into in future lessons' time, in future series. So that's like what I've said here. In this, we will potentially do a module on consumer rights law in the future, but for now, we're going to just spend a little bit of time talking about the way in which terms may be implied into contracts under the 2015 Consumer Rights Act. So one of the provisions within the Consumer Rights Act provides that goods which are sold, bought and sold by consumers, and obviously sold by producers, ought to be of good, satisfactory quality. This is outlined in Section 9. Now, Section 9 says the following. It says that every contract to supply goods is to be treated as including a term that the quality of the goods is satisfactory. The quality of goods is satisfactory if they meet the standard that a reasonable person would consider satisfactory. So, firstly, Section 9, subsection 1 makes it clear that every single contract to supply goods is to be treated as including a term that the quality of the goods is satisfactory. This is a term that is implied into the contract, hence the phrase is to be treated as including. What we mean here, therefore, is that if there is a contract to supply goods that does not include explicitly a term relating to the quality of the goods being satisfactory, it is irrelevant that that isn't present in the contract, because any and every contract that supplies goods will be treated as including this term as per Section 9 of the Consumer Rights Act. So the implied nature of the term comes from subsection 1 of section 9, and then subsection 2 of section 9 gives us the definition of what we mean by satisfactory. It is an objective standard, as we can see here, that a reasonable person would consider satisfactory. But it also allows us to take into account a number of factors which can come to and allow for a consumer to come to a better conclusion, or a reasonable person to come to a better conclusion as to how we determine satisfactory quality. So, this includes the description of the goods. This includes the price or other consideration of the goods. It includes all other relevant circumstances. The quality of the goods includes their state and condition, and the following aspects, among others, are, in appropriate cases, aspects of the quality of goods. Fitness, for all the purposes for which the goods of that kind are usually supplied, so comparing that goods to any other good of that nature that is usually supplied to consumers. The appearance and the finish of the goods, depending on the type of goods that we are talking about, of course, the appearance and finish will give quite a lot of an indication of as to the satisfactory quality of that particular product. Freedom from minor defects, safety, durability, all of which are considerations that are necessary for understanding whether or not goods are satisfactory as per Section 9. So, section 9, subsection 4 says that, quote, the term mentioned in subsection 1 does not cover anything which makes the quality of the goods unsatisfactory, which is specifically drawn to the consumer's attention before the contract is made, where the consumer examines the goods before the contract is made, which that examination ought to reveal, or in the case of a contract to supply goods by sample, which would have been apparent on a reasonable examination of that sample, of the sample in question. So this is providing something of a limitation to what section 9 subsection 1 actually implies into a contract supplying goods. It is something of a removal of suggesting that it implies any term for the quality of the goods being satisfactory. It does not cover anything which makes the quality of the goods unsatisfactory. So that's one of the main areas in which the Consumer Rights Act from 2015 is able to imply into a contract terms relating to the quality of goods. Now, we will get to remedies in future lessons' time in more detail when we talk about the remedies generally to contracts. But for now, let's have a look at some of the remedies which are proposed within the Consumer Rights Act of 2015 for violations specifically of these kinds of provisions. So, for example, Section 19 says that, quote, if the goods do not conform to the contract because of a breach of any of the terms described in Sections 9, 10, 11, 13, and 14, or if they do not conform to the contract under Section 16, the consumer's rights are short-term right to reject. This is found in Sections 20 to Sections 22 of the Consumer Rights Act. The right to repair or replace, which is found in Section 23, and the right to a price reduction, or the final right to reject, as is in Section 20 and then in Sections 24, all of which gives an indication of the processes for remedies by which you can actually essentially reject the goods in question because they do not perform and do not conform to the basic satisfactory qualities and standards that are required as per Sections 9, 10, 11, 13, and 14. Or you can have a right to price reduction, right to repair or replacement. So fundamentally, these are instances in which we can imply terms into a contract for the purposes of consumer protection and to protect consumer rights. We're planning on attacking this subject in far more detail when we do a series on consumer rights law. So if you feel like at the time being, at the time of recording at least, that this isn't enough detail, then please come back when we do consumer rights law and we start to unpack this in far more detail. For those of you who are watching this video in the future, in maybe 3 or 4 or 5 years' time, and we already have a series on consumer rights law, then feel free to go over to that playlist when it is made for more detail on this particular topic.